S. Sahaj Vidhi www.sahajvidhi.in Question 1. C. Critically examine, with the help of decided cases, the power of the President to consult the Supreme Court. Model answer. The power of the President of India to consult the Supreme Court is enshrined in Article 143 of the Constitution, which grants the Supreme Court advisory jurisdiction. This unique provision allows the President to seek the Court's opinion on questions of law or fact, thereby enabling the executive to obtain authoritative legal guidance on matters of public importance before taking action. Nature and scope of Article 143. Article 143 has two clauses. 1. Article 143. 1. If at any time it appears to the President that a question of law or fact has arisen, or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to the Court. In this case, the Supreme Court may, discretionary, give its opinion after such as it thinks fit. 2. Article 6ea3g3s The President shall, mandatory, refer to the Supreme Court for its opinion any dispute arising out of any pre-Constitution treaty, agreement, covenant, engagement, sanad, or other similar instrument. The Court shall give its opinion after such hearing as it thinks fit. Characteristics of advisory opinions. Non-binding. The opinion rendered by the Supreme Court under Article 143 is advisory and not binding on the President. The President is free to accept or reject it. 1. Not a judicial pronouncement. It is not a judgment, decree, or order in the traditional sense. It does not have the force of law and cannot be executed as such. It is merely an opinion, no adversarial litigation. While the Court hears arguments from various parties, it does not involve a dispute between litigating parties in the same way as regular judicial proceedings. Critical examination with decided cases. Advantages. 1. Authoritative legal guidance. It provides the executive with an authoritative interpretation of complex legal and constitutional issues, helping to avoid future litigation and ensuring constitutional governance. In Re Barabari Union, 1960, the President sought the SC's opinion on whether a constitutional amendment was necessary to cede Indian territory to Pakistan. The SC advised that an amendment was required, which led to the Ninth Amendment. This demonstrated the utility of advisory opinions in guiding significant policy decisions. Key. 2. Preventive measure. It allows the government to ascertain the legality or constitutionality of a proposed action or legislation before it is implemented, thus preventing potential constitutional crises. In Re Kerala Education Bill, 1958, the President sought the SC's opinion on the constitutionality of certain provisions of the Kerala Education Bill. The SC's opinion helped in shaping the final form of the legislation. 3. Strengthening constitutionalism. It reinforces the role of the Supreme Court as the ultimate interpreter of the Constitution and a guardian of constitutional principles. Disadvantages and criticisms. 1. Non-binding nature. The fact that the opinion is not binding can undermine its effectiveness. If the President chooses to disregard it, the entire exercise becomes futile. 2. Blurring of roles. Critics argue that it blurs the lines between the executive and judicial functions. The Court, in an advisory capacity, acts more like a legal advisor to the government rather than an independent adjudicator. 3. Lack of adversarial process. Advisory opinions are given without the full benefit of a concrete dispute between parties, which is essential for a robust judicial determination. The absence of a lease dispute can lead to abstract or hypothetical opinions. For potential for misuse, the executive might use this power to seek political legitimacy for its actions or to shift the burden of difficult decisions onto the judiciary. 5. Judicial discretion. Article 143. 1. The Supreme Court's discretion to refuse to give an opinion under Article 143. 1. Can be a point of contention. In Re Ayodhya dispute, 1994, the President referred a question of fact, whether a temple existed at the disputed site before the mosque, to the SC. The SC declined to give an opinion, stating that the reference was not a question of law but a factual determination, which was outside its advisory jurisdiction. It also noted that the reference was likely to be infructuous and would not serve any purpose, highlighting the Court's reluctance P. to involved irregularly in charged Ayatra disputes. In Re SC did give an opinion on doubts regarding the election of the President, demonstrating its willingness to advise on constitutional procedural matters. Conclusion: Article 143 is a valuable constitutional tool that allows for a dialogue between the executive and the judiciary, promoting legal clarity and constitutional governance. While it offers significant advantages in guiding policy and preventing constitutional pitfalls, its non-binding nature, potential for misuse, and the Supreme Court's discretion in accepting references under Article 143(1) are points of critical consideration. The Court, through its cautious approach in cases like Ayodhya, has demonstrated its awareness of these limitations and its commitment to maintaining its judicial independence and integrity, even while exercising its advisory role. Public. Please visit our website www.sahajvidhi.in for more content.